Good evening, everyone. My name is Caoimhe Gleeson, and I'm from the HSE National Office for Human Rights and Equality Policy. I'm delighted to welcome you all to this evening's webinar on getting ready for Advance Healthcare Directives. We are going to be joined this evening by almost 2,000 people from across health and social care, all of whom have, or many of whom have submitted many questions, which we will endeavour to answer in the presentations and then in the Q&A after the presentation session. Today's webinar is being organised by the National Office for Human Rights and Equality Policy. Our office is leading the preparation of the HSE for the commencement of the Assisted Decision-Making Capacity Act 2015, of which Advance Healthcare Directives is one of those components. We also have oversight of the HSE National Consent Policy, which includes the DNAR policy. We have 2 CPD points from the RCPI and 2 CEU points from the NMBI for today's webinar. We'll be sending out an email with a certificate of attendance to all attendees following this event for your records. To note, the certificate is only for those who attend the live event. Details of how to apply for RCPI CPD will be circulated with this email. Those members or those attendees who are members of CORU, the Law Society or the Dental Council of Ireland, can also use the certificate as proof of attendance for your own CPD record. The question function is open. We will try to address your technical issues through this function. Please post your technical questions in this function to all panelists, not to the host, to make sure that one of us is able to address those issues. If you have issues with sound or imagery, it's to do with your connectivity, but the recorded version will be clear. Please post any questions you have on the content of the presentation during the questions, and we will also endeavour to respond. I would now like to hand you over to Dr. Siobhan Ní, who is the National Director for Integrated Care for the HSE, who will chair our session. Thank you.
Thank you, Caoimhe, for that. And everybody, you're welcome this evening to this webinar on Advanced Healthcare Directives. So as you all know, the Assisted Decision-Making Act is finally due for commencement on the 26th of April. And there are a number of components to the Act. But today, we're specifically focused on the issue of Advanced Healthcare Directives. From talking to colleagues in clinical practice and on the front line, I know there's some anxiety about this. But I think what we really want to achieve today is to assure you that there is going to be time to learn and develop our knowledge about advanced healthcare directives. We're not anticipating a big bang on the 26th of April with regard to advanced healthcare directives. The experience in other jurisdictions has been that it takes some time to become embedded in the work that patients do on their care and indeed in our own clinical practice. The other thing that's important to say that this is part of a journey for Irish people to start thinking, planning ahead and working on their own future healthcare plans. It will take a little bit of time before the register is ready with advanced healthcare directives. So again, we will be taking the opportunity to use that time to support our colleagues in clinical and frontline practice in the use of advanced healthcare directives. So just to give you a brief outline of what we're hoping to achieve today, just to answer questions that you may have and have already been submitted on the issue of AHDs. And then I'm just going to introduce our panelists who are going to give us talks on different aspects of AHDs. So briefly, we have Professor Mary Donnelly, who's from the School of Law in UCC and co-chair of the HSE Assisted Decision Making Act Steering Group. Professor Sean O'Keefe, consultant geriatrician from University Hospital Galway, and also co-chair of the ADM group with Mary. I'm delighted also that we have Anya Flynn, who's director of the Decision Support Service, and Professor Brendan Kelly, professor of psychiatry in Trinity College. And last but definitely not least, Joanne Condon, acting national manager, National Advocacy Service for People with Disabilities. So each of our presenters is going to give a talk on their aspect of AHDs. And after that, we'll take an opportunity to answer some questions. I just want to note as well some thanks particularly to colleagues in the Irish Hospice Foundation who've been building on this work for years to help and support their own patients in developing care planning and advanced healthcare planning. I also want to call out the ministerially appointed multidisciplinary committee on AHDs, which has been managed by the HSE and has done a huge amount of work here. And just to note finally, before we hand over to Mary, that there has been some work over the last couple of years during the pandemic in introducing the idea of advanced healthcare planning. So we had that with the development of the ethical framework for care, which was produced by the Department of Health in conjunction with ourselves and the HSE and other colleagues. And we've also done additional work in the last 2 to 3 years on the DNAR policy. So they're areas where we're hoping to continue to build on. And on that note, I'm now going to hand over to Professor Mary Donnelly from the School of Law, who's going to give us an overview of AHDs from the legal perspective. Thank you, Mary.
So in this presentation, I'm going to talk about Advance Healthcare Directives, providing an overview of the role of Advance Healthcare Directives with, of course, specific reference to Advance Healthcare Directives in the Assisted Decision Making Act. So I think we're all fairly familiar with what an Advance Healthcare Directive is. Here's a generally used description. It's a legally enforceable decision about healthcare made in advance, which will remain enforceable in the event that the person who made the decision loses capacity. The term, which is sometimes used as an alternative, is living will, although that tends to be used somewhat less these days. Advanced Healthcare Directives originated in Jehovah's Witness communities back in the 1970s, particularly in the United States, where Jehovah's Witnesses were concerned to ensure that they did not receive blood or blood products, and used Advanced Healthcare Directives to do that. The idea of an Advanced Healthcare Directive is grounded in the right to refuse treatment, the legal right to refuse treatment, which of course is in turn grounded in the legal right of autonomy, the person's right to choose what happens to their own body. Most countries at this stage have statutes governing Advanced Healthcare Directives. Such statutes came in the States, in the United States, in the 1980s, Australia, New Zealand, late 1990s, and throughout Europe, really through the 2000s. So most countries have something. Most of the time, Advanced Healthcare Directives are used in end-of-life care, but they are becoming globally increasingly popular in mental health. So if we look at the Irish situation before the commencement of the Assisted Decision Making Act on the 26th of April, we see that the right to refuse treatment, both contemporaneously and in advance, has been affirmed by the Irish courts. Having said that, we've not ever had a really detailed treatment by the Irish courts. So a lot of the detail on that is simply not there. There is more detail in the Medical Council Guide to Professional Conduct and Ethics, and I've extracted there on your screen some of the key elements from paragraph 16 of the 8th edition of the guide. So you'll see there an obligation to do your best to help and support patients who want assistance in writing an advanced healthcare plan. Ask people if they have made an advanced healthcare plan, if they have life-limiting conditions, and a very clear statement that an advanced healthcare directive has the same status as a contemporaneous decision, provided it's an informed choice, it covers the situation in question, and nothing indicates that the patient has changed their mind. The Medical Council is also clear that there's no obligation to provide treatment that is not clinically indicated, and that if questions arise and the clinician is unsure of the position, I suppose, of the Advanced Healthcare Directive, decisions should be made on the basis of best interests. Obviously, some elements of that will have to change now that we have the Assisted Decision Making Capacity Act. So just to identify some of the key elements of Advanced Healthcare Directives in the Act, and we're talking here about the 2015 Act, which was, of course, amended by the 2022 Act. So I'm talking about the amended Act here. So it adopts a definition of an Advanced Healthcare Directive as an advance expression made by a person of his or her will and preferences concerning treatment decisions that may arise in respect of him or her if he or she subsequently lacks capacity. So I suppose the first couple of points to note there are that Advance Healthcare Directives are very much restricted just to treatment decisions, although as you'll see there on the slide, there's a relatively broad interpretation of treatment taken in the Act. Two things which are worth saying at this point also. Our Assisted Decision Making Act provides for directives to both refuse and request treatment, although there is a different legal status depending on which of those someone is doing. And something else which we'll talk about a little more later, the Act allows the appointment of a designated healthcare representative. And again, I'll talk a little bit more about that. That's a relatively innovative measure, and I think a very good one in our Act. A second point to note is that the only way a person can make an advance decision about their health or empower someone else to make decisions in that regard is through the AHD mechanism. It's not possible to use an enduring power of attorney to make treatment decisions. So whilst you can appoint enduring powers of attorney for all sorts of other decisions, you cannot, or a person cannot, appoint an enduring power of attorney or grant an enduring power of attorney in relation to treatment decisions. I should also say at this point that the Decision Support Service has developed a code of practice on Advance Healthcare Directives, and that should shortly be available. And that I think you will find helpful. It provides a much more user-friendly version of how Advance Healthcare Directives work than the more, I suppose, legalistic language of the Act itself. So briefly to take you through the requirements which someone must meet in order to make an Advance Healthcare Directive. The directive maker has to be over 18. They must have decision-making capacity. However, interestingly, there is no requirement in the Act that they must have proof of or have had a test or an assessment of decision-making capacity prior to making an Advance Healthcare Directive. So essentially the presumption of capacity applies. And as you know, under the Act, everyone is presumed to have capacity. The requirement for capacity doesn't mean a person can't be supported. They can be supported informally, or they can be supported by a decision-making assistant to make their Advance Healthcare Directive. Importantly to note, however, that a person cannot be supported by a co-decision maker. In other words, you can't make a joint Advance Healthcare Directive using a co-decision maker. Has to be in writing, has to be signed, both by the directive maker and by the designated healthcare representative, if there is one, and we'll come back to them in a minute. Has to have name, date of birth and contact details, has to be witnessed, and 2 witnesses, and one of whom must not be an immediate family member. There's also a requirement that there must be an express statement in relation to life-saving or sustaining treatment, if that's to apply. Now, it's important to remember there is no form for an AHD. Once those requirements are met, you have an AHD. However, it is also worth noting that the DSS will host on its site a template which people may choose to use. However, that template is not in any way mandatory or obligatory. It's the requirements which I've set out on this slide, which must be met in order for an AHD to be an AHD. So to talk briefly about requests for treatment, you remember I identified that these are treated differently to refusals. Requests for treatment are not legally binding. However, they do have a degree of authority. They must be taken into consideration in deciding the most appropriate treatment for the person, if they're relevant to the condition for which the person is being treated. Moreover, if a decision is taken not to accord with a request for treatment, the reasons for that decision must be communicated to the designated healthcare representative, and that must happen within 7 days of the decision to not take account of the request. Refusals of treatment are the legally binding element of the Act. So refusals are legally binding, but only if they're valid and applicable. I'm going to take you through the requirements for that in a moment. The person who decides in the first instance if the refusal is valid and applicable, if the AHD in this regard is valid and applicable, is the clinician who is proposing to provide the treatment. Obviously, in some instances, consultation, etc., would be advisable in this circumstance. We'll talk a little more about that later. In terms of the requirements for validity and applicability, it requires first, the AHD must be voluntarily made. The directive maker must not have done something inconsistent with what they state in their Advance Healthcare Directive. However, that under the Act applies only while the person has capacity. So they must not, while they have capacity, have done something inconsistent. The directive maker must lack capacity at the time the treatment decision has to be made. If they don't lack capacity, if they're capable of making a decision contemporaneously, then the AHD does not come into effect. The treatment referred to in the Advance Healthcare Directive must be materially the same as the treatment at issue. And similarly, the circumstances referred to in the directive must be materially the same as those referred to in the Advance Healthcare Directive. So in both respects, you'll see a degree of specificity there, and there must be a clear match, both in terms of treatment and in terms of circumstances. And as I mentioned earlier, if we're talking about life-sustaining treatment, there must be a specific statement that the AHD is to apply, even if the result of the application will be the death of the person. We've got 2 exceptions to the right to refuse treatment in an AHD. The first relates to basic care. So the idea here is that you can't bind yourself to refuse certain basic care in your should you lose capacity. Basic care is defined by the Act as including warmth, shelter, food and liquids provided orally, and hygiene measures. Interestingly, the Act says, and you'll see I've reproduced it there on the slide, it includes but is not limited to, but these are the specific features, I suppose, of basic care that you will see. The Act also specifically says that basic care does not include artificial nutrition and hydration. So it is possible in an AHD to refuse artificial nutrition and hydration. The other exception to the right to refuse treatment in an AHD applies to some people who have been admitted under the Mental Health Act, specifically people who've been admitted under the risk ground. But I know Brendan is going to talk further about that. Just to introduce you to the idea of the designated healthcare representative. As I said earlier, this is a specific feature of the Irish model. It's a good one, I think. People don't have to appoint a designated healthcare representative, but when they do, there's somebody there to, in a sense, represent their views and speak to the directive and represent the directive at a time when the directive maker lacks capacity. So a designated healthcare representative has the power to ensure that the conditions of the Advance Healthcare Directive are complied with. They can also be additionally empowered by the directive maker to advise and interpret the directive maker's will and preference in accordance with their AHD, and to consent to and refuse treatment. And that can include life-sustaining treatment, again, if they're specifically empowered in that regard. What the designated healthcare representative introduces is provision for a degree of nuance and a degree of a more nuanced response to issues than you might get in a simple, as it were, paper-based response, which is what you've got in your standard Advance Healthcare Directive. In terms of determining validity and applicability, there may inevitably be ambiguity, and the Act does provide guidance to clinicians, to healthcare professionals in such circumstances. They must consult with a designated healthcare representative if there is one. So again, this, I suppose, shows the value of having a designated healthcare representative. If there's no designated healthcare representative, they must consult with the directive maker's family and friends and seek the opinion of a second healthcare professional. So that idea of consultation is very much written into the Act as a way of resolving ambiguity. If ultimately ambiguity cannot be resolved, it must be resolved, as it were, in favor of preserving the directive maker's life. So there is a balance at the end, and that's in favor of preserving the directive maker's life. And then finally, I want to talk a little bit about liability and the statutory protections from liability which are in the Act, because I know some people have concerns about liability under the Act. So the Act contains two specific statutory protections for liability for healthcare professionals. As you'll see there is no liability, either civil or criminal, where a healthcare professional complies with the refusal of treatment in an AHD, and he or she had reasonable grounds to believe, and they did believe, that the AHD was valid and applicable. So in other words, if a decision is made, compliance with the AHD happens, and it is subsequently shown that the AHD was not in fact valid or applicable, there is no liability for the healthcare professional in that circumstance. The reverse is also true, where a healthcare professional does not comply with the refusal of treatment, and he or she has reasonable grounds to believe, and did believe, that the AHD was not valid and applicable, they cannot be liable for refusing to comply with the AHD. And you'll notice there that there must both be that objective element, a reasonable grounds to believe that the AHD was valid or invalid, depending on the circumstance, but there must also be the subjective element. The healthcare professional must also have actually believed that. And then the other position or protection from liability, statutory protection from liability, and I think this may bring some comfort to people who are worried that they won't have access to the AHD. There's no liability where a healthcare professional did not act in compliance with refusal of treatment where, at the time, he or she had no grounds to believe that the Advance Healthcare Directive existed. So if you don't know about it, you can't comply with it, and that's very clearly recognised in the Act. Or where someone has grounds to believe that the Advance Healthcare Directive existed, but has no immediate access to it and its contents, and the urgency of the condition of the person is such that the healthcare professional could not reasonably delay taking appropriate action until he or she did have access. So as you'll see there, the Act has gone to some lengths to ensure protections and recognise, I suppose, the pressures that arise on people on the ground in giving effect to Advance Healthcare Directives. Thank you.
Mary, thank you so much for that. And I think the last slide on statutory liability should be helpful to us colleagues. I'm now going to call on Professor Sean O'Keefe, who's going to give us an overview of AHDs with practical and clinical considerations. Sean, you're very welcome.
Hello, everyone. I'm going to flesh out a bit some of the implications for practice based on what Mary has told you already. This is a somewhat daunting list of professional responsibilities. Is the capacity of the person to make the decision in question? Because if it isn't, then any Advanced Healthcare Directive is irrelevant. If it is in question, then you need to take reasonable steps, and we appreciate there may be little time in an emergency to see if the person has an AHD, and that can include asking the person themselves or anybody with them, and when there's a register, consulting it. And then you read the AHD, and verbal reports really aren't sufficient. Are the formalities complied with? Is it valid and applicable to the particular situation they're in? And is there a designated healthcare representative? You need to be sure that the person actually lacks capacity to make the decision, because if they're able to make it with supports, then they should make it themselves. But if they aren't, then you respond to the AHD, and in particular, a valid and applicable AHD, one must comply with a refusal of treatment, and then ensure others are also aware of the AHD, including other professionals, for example, and particularly when care is being transferred to a different service, and ensure, where practicable, that the AHD is accurately recorded on relevant medical records. We've come across a number of repeated questions during the educational material about AHD. One is, will there be a standard form? And the answer is yes, there will be a form hosted on the Decision Support Service website that people can download and use. But this isn't going to be a single mandatory form, and an AHD complying with requirements and valid and applicable can be done on other ways of advanced healthcare planning, or even homemade forms, for example. And an AHD made outside the state, which substantially complies with our requirements, will have the same force as if it were made in Ireland. Anya is going to speak later about the idea of the register of Advanced Healthcare Directives. There will eventually be a register, but not a commencement. That won't prevent implementation of AHDs, and it's important to note that the register is never going to be a panacea, and a failure to register won't invalidate an otherwise valid and applicable AHD. Does there need to be medical or legal input to create an AHD? No, people can create them themselves without seeking advice. On the other hand, the guidance to the public will recommend seeking advice. First of all, doctors will need to know about it to comply with them, and it will also make AHDs more comprehensible and increase the likelihood that the person's wishes will be understood. There is no requirement that AHDs are reviewed after a certain time. Again, on the other hand, it's a good idea to review it as life circumstances change and update it if necessary. Healthcare professionals can be witnesses to an AHD, although there's no obligation to do so. And it's important to note that acting as a witness doesn't mean that you agree with or even that you're aware of the contents of an AHD. How do I know the person had capacity when they wrote the AHD? Well, this is something that generally should be presumed in most cases. There may be rare exceptions where there may be reason to question that, but at the time the AHD is to take effect, it's not necessary to make inquiries as to the capacity of the directive maker. How do I know an AHD is valid? Well, you recall from Mary's talk that there are two things that would invalidate it. One is if there were coercion or undue pressure. It's reasonable to presume it was made voluntarily unless there are good grounds for concern otherwise based on evidence. It's also important to note that actually advising someone to make an AHD is not the same as coercion or undue pressure. The second thing that might invalidate it is if they'd done something clearly inconsistent with the AHD. And we appreciate that in an emergency, you won't have time to be searching through the old notes, but sometimes it's clear cut. What if you disagree with a refusal of treatment in the AHD? Well, a failure to comply with a valid and applicable AHD does carry potential civil and criminal liabilities. Conscientious objection can't lead to restriction of the rights and freedoms of another person. So healthcare professionals can't override an AHD because they disagree with it. One question that's come up repeatedly, somewhat to our surprise, is the idea that the hospital or whatever setting DNA CPR policy must be recorded on a particular form, and that the AHD doesn't count until it's recorded on that form. And that's the wrong way around. The AHD is a legal document, and DNAR policies in hospitals and elsewhere will have to adjust to AHDs, not the other way around. There is going to be a challenge for healthcare systems as to how we best record them, record their existence in detail, and how we communicate between staff about an AHD. But these practical issues don't mean that the HD isn't a legal document right from the outset and must be obeyed, particularly with a refusal of treatment. A really important point is that not all DNR decisions will need an advanced healthcare directive. Ordinary advanced care planning will continue, and to remember that these are complementary. The kind of planning that occurs often in hospitals where there's discussion between the healthcare professional and the patient, and the professional documents the outcome of that discussion. That's not a healthcare directive, and it can continue and will continue to be useful. But the Advanced Healthcare Directive is different in that the refusal is legally binding and it's a legal document. People often ask about emergency situations, and we can understand the concern of people facing documents when they're trying to deal with an emergency. First of all, I didn't know there was one. Well, that's not your fault. The onus is on the person to disseminate them and tell others. And in that case, you treat as usual, prevent harm and injury and death, and there's no liability. The same goes in the situation that's so dire that you've no time to be reading an AHD. You provide whatever treatment is immediately necessary, and they're the important words, pending a review of the HD. If the HD is unclear, then what the law requires that you ask the designated healthcare representative, if available, and there is one, and then get a second opinion from a colleague. If it's still unclear, then again provide the treatment immediately necessary, pending review. Sometimes there may be a late discovery of a healthcare directive, in which case you consider whether the HD is relevant to any continuing treatment. It may be too late, for example, not to provide CPR, but it may be relevant to a person's requirement that they not be ventilated. And any ongoing treatment will need to be reviewed and withdrawn if it falls within a valid and applicable Advanced Healthcare Directive. I'm going to give an example here, and this is a lady with advanced dementia, and she comes into hospital, and the daughter reports that she had an HD, refusing CPR and ventilation, but the daughter couldn't find it in the rush and the panic of her mother getting short of breath. If it can't be accessed and read, then there is no legally binding HD to respect. But hold on a second. Mary, the daughter, is the one who best knows her mother's will and preference. And the fact that her mother went to the bother of drawing up an HD is a very strong guide to the strength of her will and preferences. And the preference, of course, not to have aggressive treatment in these circumstances seems reasonable and understandable. In that case, I think it's reasonable not to perform the CPR and ventilation, and it often mightn't be clinically indicated even, and to document the reasons, including the reported will and preference, but you don't get the protection of relying on the healthcare directive. We asked about validity earlier, but is it applicable? Well, there are two requirements in particular that stand out. The treatment must be materially the same, and of course it mustn't be basic care. It's important not to get hung up about minor differences in terminology, and that shouldn't prevent an AHD from being applicable. And of course, if it's going to refuse life-sustaining treatment, that must include an explicit statement that the directive maker understands that their life is at risk as a result of refusing treatment. A second important aspect of applicability is, are the circumstances materially the same? Are the specific circumstances the same or very similar to those in which the treatment is now being proposed? And again, minor variation shouldn't prevent an AHD from being applicable, and people may apply specific circumstances dependent on their cultural beliefs or lifestyle or ethics, or indeed on specific medical conditions. I think certainly the circumstances can sometimes give rise to uncertainty or ambiguity, and that may occur if life circumstances have changed greatly, and sometimes the wording may be somewhat unclear. We'll talk about in all circumstances or in no circumstances, but even the phrase in a coma or comatose, that's not very helpful and isn't specific enough, because it could be transient or prolonged, or it could be reversible, and people need to be clear about it if they mean if they're in a prolonged coma with no chance realistically of recovery. Similarly, things like having a stroke or having severe stroke or dementia or disability. How severe? What do people mean by severity? And these are among the reasons why people will often be well advised to discuss it with their doctors while drawing them up. But if there is this uncertainty, to remind you of consulting the healthcare representative or family and friends and seeking a second opinion. And if unclear, you act to preserve life and health. Here's an example of one where in any circumstances gives rise to some difficulty, where Mr. J has severe cardiorespiratory disease and multiple admissions as a result, and he says he doesn't want to be readmitted to hospital in any circumstance, except that at the time when he has delirium and is unable to make his own decisions, he has a fall and has a gash that requires suturing. And his GP, I think reasonably here, considers that the in any circumstances too unclear, that Mr. J may well have been considering refusing another admission to hospital with cardiorespiratory exacerbation, but mightn't have considered the possibility of needing to come in and have a few sutures. So again, she discusses it with her colleague and sends Mr. J to the emergency department to have the wound stitched. And if the man had had a designated healthcare representative, that would have been very helpful, because he or she could have clarified his intentions. I want to look at one area, and Mary's mentioned this phrase already: no liability for failure to comply with a healthcare directive if a professional had reasonable grounds to believe and did believe that refusal of treatment was not valid or applicable, or both. It's important to say "and did believe" there. It means we're meant to act in good faith and with integrity. We're not trying to look for loopholes or a way of wiggling out from complying with a healthcare directive we don't agree with. So it's not just reasonable grounds, but you must genuinely believe, for example, that there's a lack of validity or applicability. Just a quick word on the power of the designated healthcare representative. They can interpret and advise on the directive maker's will and preference, or they can consent and refuse treatment, up to refusing life-sustaining treatment, depending on the powers given to them by the directive maker. And their interpretation takes priority over the views of anybody else. It is important, though, they're there to be based on the will and preference of the directive maker, so their personal views aren't relevant, and they can't just override a healthcare directive because they don't like it. Let's give an example again where Mrs. A appointed her friend as a designated healthcare representative with the power to provide or refuse consent. And when she becomes very ill and can't speak for herself for a chest infection, then her friend tells staff that based on her knowledge of Mrs. A's will and preference, she's not for CPR or ventilation. And then her only child comes back from Australia and demands that she receive all treatment, including CPR if necessary, and says that he's the closest relative and his views should be most important. And staff will have to inform that Miss B is the legal decision maker and that her refusal of treatment on Mrs. A's behalf must be obeyed. So it's a very important and indeed powerful role that a designated healthcare representative. On April 26th, there isn't going to be a big bang with ADM or indeed with healthcare directives. There'll be very few of them immediately, and we'll continue advanced care planning as before when dealing with current illness. If we look at other countries, I think with time, in the USA, about 20% of the population is particularly white and educated and wealthy. And then not unexpectedly, those who are chronically or terminally ill. And in Europe, a little bit less after many years, about 10 to 25% in different countries in Europe. So we'll see what will happen, and thank you very much for your attention.
Sean, thank you very much for that. Really practical advice for clinicians with regard to AHDs. If there's one point I want to make before we move on to our next speaker, and that is to, apologies for that, that is to be aware of the importance of contemporaneous note making when you're making decisions about the use or otherwise of AHDs when you see patients. I think that's something the State Claims Agency has emphasised to us, and I've emphasised to colleagues again, very important to document your decision making at the time when making decisions for patient care. I'm now going to hand over to Anya Flynn, who's going to talk to us about the codes of practice, the register for AHDs, and the form template. Anya, you're very welcome, and thank you.
And thank you very much for having me to speak on this subject. The Decision Support Service has quite limited interaction with Advance Healthcare Directives. So what I have to say to you is quite practical and relatively brief. If we think about the primary functions of the Director of the Decision Support Service, where they are at Section 95, we have overall duties to promote and to provide information about the 2015 Act generally, to register arrangements and to supervise the operation of decision support arrangements. So those registration and supervision functions don't actually apply in the same way to Advance Healthcare Directives as they do to some of the other arrangements under the Act. But certainly we do have that broad duty, as I say, to promote public awareness and confidence in relation to the 2015 Act. One point I might just mention here, for want of anywhere better to mention it, is that when people are thinking about planning ahead, they should be aware that an enduring power of attorney isn't a vehicle for planning ahead for medical treatment decisions, and that's exclusively a matter for an Advance Healthcare Directive. We have that overarching duty as well to provide information to all of the decision supporters under the Act, and that would include a designated healthcare representative appointed under an Advance Healthcare Directive to give them that information in relation to the performance of their functions, and also a duty to provide information and guidance to organisations and bodies in the state in relation to all of those decision supporters, and that will include information and guidance in relation to their interaction with designated healthcare representatives. And perhaps important to remind you here that the DSS does not provide legal advice. We don't go beyond information and in some cases guidance. So as you will know, Part 8 of the Act is the Act that deals with Advanced Healthcare Directives, and the rest of the Assisted Decision-Making Capacity Act is the business of the Department of Children, Equality, Disability, Integration and Youth, but Part 8 falls to the Minister for Health. And the Minister for Health, and I'm quoting here from Section 84, may specify and publish forms of Advanced Healthcare Directives that may be used and adapted. And the may is significant. It's may rather than shall in the other parts of the Act. The other minister shall publish regulations, but here it's may only. And then thinking about those template Advanced Healthcare Directives, one has been drafted and is, as we speak, awaiting a formal approval by the Department of Health. And the DSS has undertaken to publish that template on our website by way of good information. But really important to note, this is not by any means the only acceptable template. You'll be hearing from other speakers about what are the essential features of an Advanced Healthcare Directive. And this template, this approved template, when we publish it, is certainly not the only acceptable format. Other formats may well fulfill the requirements for validity and essential contents. Similarly, and sticking with may, the Minister for Health may make those regulations, and these may be regulations to require a directive maker, so anyone making an AHD, to notify us in the DSS and perhaps other notice parties of the fact that they have made an AHD. And also the Minister may then make regulations requiring us in the DSS to establish a register of AHDs. And we know there has been a lot of discussion and anticipation about such a register. Because those regulations are pending, and we understand there is an intention that they will be provided ultimately, but they don't exist yet, we will not have a register of AHDs in the DSS on commencement or until those regulations exist. Bear in mind, however, and this is important, an AHD is different from some of the other decision support arrangements under the Act in that it does not and never will require to be registered in order to be a valid and potentially applicable document. So important to know that. And when we do see regulations, we'll have to consider, and I'm sure the department will be considering, well, what is the significance, therefore, of notifying an AHD to the DSS? What is required of us in the DSS? What's the significance of that ending up on a register? Remembering, of course, that an AHD is well capable of being a valid and usable document without registration. Another function that will fall to us that relates to AHDs is our function to investigate complaints, and that includes a complaint made against a designated healthcare representative. So Section 88.4 provides that the Director shall receive and consider complaints and allegations in relation to the way in which a designated healthcare representative is exercising his or her powers. So the language in the Act here is fairly general, and that allows us, when we receive that complaint, to review that complaint, and if we are satisfied that it has substance, to commence and conduct an investigation. We can in fact conduct an own initiative investigation in the absence of a complaint. That should say investigation in the absence of a complaint. But we will have had no real interaction with an Advance Healthcare Directive up to this point. Nonetheless, we have that own initiative ability. And it could well be that it is a healthcare professional who becomes aware that a designated healthcare representative is acting in some way which seems to be in excess or incorrectly, and that can come to us. And we have a route then where we can apply to court, and the court may prohibit the designated healthcare representative from acting as such. When investigating those complaints, then we may summons witnesses, we can take up evidence, we can commission one of our own special or general visitors to prepare a report, and we are authorised to resolve complaints about designated healthcare representatives informally, as we are other decision supporters. We don't have a provision to apply to court for a temporary prohibition order to stop the designated healthcare representative from acting, but be aware that under Section 89 of the Act, any interested party, and that potentially could include us in the DSS, may apply to court for a declaration as to whether a designated healthcare representative is acting in accordance with their relevant powers. So here we see that complaints function which could arise in the case of a DHR. And finally then, another piece of interaction that we will have with Advance Healthcare Directives comes with our codes of practice. You will be aware, I'm certain, that we are preparing to publish 14 different codes of practice. And in respect of healthcare professionals and Advance Healthcare Directives, these were originally drafted by a ministerial working group working under the HSC and with various expert input and consultation was carried out both at the drafting stage, and then we conducted a public consultation on the final drafts during last year. So among the 14 codes, there is an overall one providing guidance to healthcare professionals, specific guidance in relation to Advance Healthcare Directives, and guidance for those designated healthcare representatives. As we speak now, the codes are to be published imminently. A person concerned shall have regard to a code of practice when performing any function under the Act in respect of which the code provides guidance. So breach of one of the codes of practice doesn't give rise to any civil or criminal liability, but it's something that may be taken into account in other proceedings before a court or tribunal. And I should say, when those codes are published, it will be together with other guidance documents and associated vignettes. So that is that's enough from the Decision Support Service. As I say, our points of interface with Advance Healthcare Directives and with designated healthcare representatives are comparatively limited compared to other parts of the Act, but we do have that overarching duty to supply information and guidance. And if you are encountering queries about what is an Advance Healthcare Directive, how do I make one, then we are answering queries already, and you can see how to contact us here. Thank you very much.
Anya, thank you. Thank you very much for that. I'm going to now move to Professor Brendan Kelly, who's going to talk to us about AHDs in the context of mental health services. Brendan, you're very welcome. Thank you.
I'm going to talk today about advanced healthcare directives in mental health services in particular, and looking at some of the specific considerations and issues that will arise when advanced healthcare directives are being made and are more common across our mental health services under the 2015 Act. I guess the first point to make is that the legislation and therefore the advanced healthcare directives are all about capacity, presuming capacity, giving effect to people's capacity and to their decision making. So it really is about a new and additional way to respect the will and preference of the individual, even when they're ill, when they might lack decision-making capacity, and use advanced healthcare directives as a way to address that. We know and we have heard that advanced healthcare directives are a key element in the 2015 Act, which give greater clarity about will and preferences of the person. And in mental health services, for voluntary outpatients or voluntary inpatients, an Advance Healthcare Directive applies in precisely the same way that it applies to everybody else. In other words, a refusal of a specified treatment in a valid and applicable Advance Healthcare Directive is binding and shall be complied with, and a request for a specified treatment in a valid and applicable Advance Healthcare Directive shall be taken into consideration. And that is the same for the vast majority of people attending mental health services as outpatients or as voluntary inpatients. So Advance Healthcare Directives apply in the exact same way for physical healthcare, or mental health care, for all of these patients who constitute the vast majority of people who attend mental health services. The slight complexity comes in relation to involuntary patients, and these are people whose treatment is regulated by the Mental Health Act on an involuntary basis. For these people, involuntary inpatients in psychiatric units and psychiatric hospitals, the big point to make is that Advance Healthcare Directives pertaining to physical illness apply in the exact same way as everybody else, even when a person is an involuntary patient under the Mental Health Act. If, however, the person has an Advance Healthcare Directive pertaining to mental illness, then this applies in a different way for some involuntary patients. So the only difference in mental health service pertains to some involuntary patients and their advance directives pertaining to mental illness only. For involuntary inpatients, advance directives for physical illness apply in the same way as any advance healthcare directive. So what is this exception for some involuntary inpatients regarding their advance directives pertaining to mental illness? Well, they apply, but in a different way. The amending legislation reads as follows, that an advance healthcare directive shall, insofar as provided for in this part, be complied with unless, when it is proposed to treat the directive maker, their treatment is regulated by Part 4 of the Mental Health Act, which means they are an involuntary patient, other than where they are detained on the grounds they have a mental disorder within the meaning of Section 3(1)(b), or when they're the subject of conditional discharge. Now, this piece of amending legislation is exceptionally difficult to understand. I'll be honest here, it has double negatives and all kinds of things in there. But if we unpack it and look at exactly what this means, we can figure it out. So what I've got here is a table, and this concerns psychiatry inpatients. And in the left-hand column, as you look at the screen, we have different categories of inpatients. We have voluntary patients, involuntary patients detained under the risk criterion, involuntary patients detained under the treatment criterion, and then involuntary patients detained under both of these criteria. So if we look first at the voluntary patient, this is a voluntary psychiatry inpatient. A refusal of a specified treatment for mental illness in a valid and applicable advance directive shall be complied with. This is the exact same as an outpatient or anybody across the health service. And again, it's the same as with any other part of the health service. A request for a specified treatment for mental illness in a valid and applicable advance healthcare directive shall be taken into consideration for the voluntary patient. So for the voluntary inpatient, it is the exact same as for any advance healthcare directive across any part of the health service. For an involuntary patient who is detained under the treatment criterion, this is 3(1)(b), it is the same again, that a refusal of a specified treatment for mental illness in a valid and applicable advance directive shall be complied with, and a request for a specified treatment in a valid and applicable directive shall be taken into consideration. So for psychiatry inpatients who are voluntary or involuntary under the treatment criterion of the 2001 Act, an Advance Healthcare Directive is treated the exact same as for anyone else across the health service. Now, the difference comes for a patient who is involuntary under the risk criterion. That's the second line down there in the second category of patients there in the table. For a patient detained under the risk criterion, a refusal of treatment for mental illness is not binding, but should be taken into consideration as an expression of will and preference. And a request for a specified treatment should also be taken into consideration as an expression of will and preference. So the difference here is that if an involuntary patient is involuntary under the risk criterion, their refusal of specified treatment for mental illness in a valid applicable directive is not binding. Now, that doesn't mean it should be ignored. It is still an expression of will and preference, and the advice is it should be taken into consideration. And similarly, a request for a specified treatment for mental illness for someone who is involuntary under the risk criterion should be taken into consideration as an expression of will and preferences. The final category of involuntary patient is someone who is involuntary under both of these criteria, the risk and the treatment criteria. And in this situation, again, the refusal of a specified treatment for mental illness in a valid applicable directive is not binding, but it is still an expression of will and preference and should be taken into consideration. And a request for a specified treatment should also be taken into consideration. So to summarize all of this, for people attending mental health services, for outpatients and voluntary inpatients, Advance Healthcare Directives, once they're valid and applicable, are treated the exact same as in any other part of the health service. The only difference comes for a patient who is involuntary under the risk criterion or under both the risk and treatment criteria. And for those patients, a refusal of a specified treatment is not binding, but should be taken into consideration, and a request for a specified treatment should also be taken into consideration. So that is the difference in mental health services, and it only applies to certain involuntary inpatients, depending on what criteria that involuntary status is based upon. So what will actually happen on commencement of the 2015 Act in relation to advanced directives in mental health services? At first, very little. There is not a strong tradition, to put it very gently, of advanced healthcare directives in mental health services. So it seems unlikely that there will be a sudden deluge of advanced healthcare directives. So the system will have time to adjust to this development, which is a positive development, but will be, in my view, slow to start up. So at first, very little will happen. And later on, still very little will happen unless services encourage people to make advanced healthcare directives. Now, I do have a reason for saying this, which is evidence from other jurisdictions. So, for example, if we take Scotland, Scotland introduced a new system of advance statements in its 2003 legislation, only to discover that very few people took up this option of making an advance statement. So when they did a study some years later to see why was this not done, they discovered that many people, even though advance statements were introduced in 2003, many people had never heard of them. And even if they had, they did not think they were relevant. People didn't know how to go about making an advance statement, who could be a witness, and what to do with the document when they had drawn it up. Some service users recognized that when they were unwell, they just trusted the clinical teams to provide treatment that was appropriate. And, this is a very common position, and it is, in my view, an underappreciated one. It can be a very emotionally aware, psychologically aware thing to do, to simply decide to trust others. However, advanced directives do offer a new opportunity here for expression of will and preferences. The other reason for not taking it up is people, when recovered, found it hard to contemplate being unwell again. Interestingly, other people believed no regard would be had to their advance statement, and the evidence was, in fact, all to the contrary. Advance statements that were made out in Scotland were overwhelmingly adhered to. And then finally, one of the reasons for low uptake of advance statements in Scotland was confusion about, the difference between personal statements, living wills, and so forth. So, it is a concern that similar factors will be in play here in Ireland following commencement of the 2015 Act, and it will be necessary to encourage the making of advance healthcare directives. And they are probably best made, in dialogue, in consultation, and that's going to really be a task for services once the Act commences. So the key points that I wanted to make today: advance healthcare directives are a central part of the 2015 Act and a central way to give greater effect to the will and preferences of the person. Advance healthcare directives apply to the majority of patients, the vast majority of patients in mental health services, the same as they apply to everybody else. And this is an absolutely key point. They also apply to involuntary inpatients, but with a caveat in relation to treatment for mental illness only, for some involuntary inpatients only, basically those detained under the risk criterion, either on its own or in conjunction with the treatment criterion. How these will be used in practice is largely up to mental health services and up to mental health professionals to explain about advanced healthcare directives, point out the benefits, and to sort of collaboratively encourage patients and people attending services to develop them. Thank you very much for listening.
Brendan, thank you very much for that. And I hope our participants here are getting reassurance that we're not going to be facing the big bang on the 26th of April, but that we will have time to get used to this Act in all its guises as it comes in, but particularly in relation to advanced healthcare directives. I'm now going to bring in Joanne Condon from the National Advocacy Service, who's going to talk to us about advanced healthcare directives with personal considerations and from her perspective as an advocate. Joanne, you're very welcome.
So I'm going to focus now on advanced healthcare directives more from the perspective of personal considerations and drawing really from the experience of the National Advocacy Service in supporting people with a wide variety of disabilities who may wish to make an advanced healthcare directive. So what is an AHD? Well, it's a written statement made by a person who is deemed to have capacity that sets out their preferences about medical and healthcare treatment decisions in the future, if a time should come where perhaps they would be unable to make or indeed communicate their decision. So this is a fantastic human rights tool, and we know that the United Nations Convention on the Rights of People with Disabilities states that all people have the right to make decisions and choices about their own lives and indeed to speak on their own behalves. And the Assisted Decision Making Act introduces now a statutory framework for advanced healthcare directives that's provided for under Part 8 of the Act. And why am I saying that this is a great human rights tool? Well, advanced healthcare directives do two fundamental things. The first is that it gives voice to each of us, to all people, to direct their own futures and enhance their autonomy. And secondly, it ensures that health and social care professionals have information on every person's wishes, will, and preference who choose to record it within that advanced healthcare directive. There's an important principle underlying in the Assisted Decision Making Act that's just really good to focus on when you're looking at advanced healthcare directives. And it's where the Act signals that significant shift away from a best interest approach to a rights-based approach of choice, control, and consent. For years, it was commonplace in Ireland for people with disabilities in particular to be the subject of decisions rather than active participants in their own lives. And the focus was often on what everybody else around the person thought what was best for them. In other words, what was in their best interests, without really any due consideration to what the person themselves wanted. So the assisted decision-making legislation is shifting the focus within decision-making to will and preference. And that clearly puts the person's own wishes and preferences right back at the heart of the decisions to be made. So in this context, an advanced healthcare directive ensures that a person's own wishes remain central in decisions that might be made in the future then in relation to medical and healthcare treatments. So let's have a quick look at some overview matters here. So We know that it's, as I've said, a really important instrument for upholding our rights because it provides an increased sense of control over our future treatments and decisions. Any person over the age of 18 can make an Advance Healthcare Directive at any time, and there's no cost in terms of registering with the Decision Support Service. You do not have to make an Advance Healthcare Directive if you don't want to, and you can also end an Advance Healthcare Directive at any time. The only proviso being, of course, that you have to be deemed as having capacity to do so. The Advance Healthcare Directive then also ensures that we have a right to refuse treatment, even if others consider that refusal unwise. Again, this is linking it back to the principles underlying the Act. So even where that decision may result in death, provided that the person had the decision-making capacity at the time of making the Advanced Healthcare Directives. And of course, we've already seen it outlined by previous speakers that this will, of course, not apply to certain basic care, such as warm shelter and so on. A person may then also include a request for a specific treatment, but again, as the previous speakers have already detailed, that may not be legally binding. A person can revoke their Advanced Healthcare Directive or amend it at any time, again, so long as they have capacity to do so. And a person can nominate a designated healthcare representative to make sure that their wishes are respected and communicated. And every healthcare provider that is then dealing with that person must respect their wishes to refuse any treatment that they have said they do not want. An Advanced Healthcare Directive only comes into effect if and when a person loses capacity and they're unable to communicate their healthcare decisions. So another key area that's already been covered by previous speakers in some detail is how these apply then within mental health settings. So I'm not going to go through all of the detail of this again, because I think the previous speakers have more than covered it off. But just to again reiterate that message that they also can apply for voluntary patients within mental health settings. And there being then an exception in relation to particular categories under the involuntary, which Brendan went through in a lot of detail. So I'm going to move now specifically to the how to support people and some of the personal considerations if you are going to support anybody to complete an Advanced Healthcare Directive. So some of the things to consider are, it's really good to choose a time of day that works best for the person. For some people, if you take, for example, somebody with dementia, it's often the case that at particular times of the day, they will find it easier to make decisions, and they will find that perhaps early morning works better. Everybody will be different in that regard. So it's very important to tune into that and to support a person to complete it when it suits them best. It's also important to be confident and competent in talking about Advanced Healthcare Directives and educating yourself to understand exactly what needs to be contained, which Mary outlined in some detail. And again, all of the key things to consider that decisions need to be made about. And we often find that values is often a good place to begin if you're stuck in starting that conversations, just to explore with somebody, what are the key values that might underpin some decisions that they need to consider. It's really important to give sufficient time to the person to work through their wishes. Some people will find it difficult to reach a decision on particular treatments or choices that they may wish to make, and they may need time to consider and reflect on that before they commit to a particular decision. For some people, completing small portions of this at a time may work best rather than doing it all in one go and coming back to it perhaps over the course of a number of days. It's important that people are facilitated to communicate in a way that is accessible for them. So that may need to include the provision of easy to read or visual prompts or anything else that will work to support a person to communicate in a way that works best for them. It's important that the person's own choice, rather than the voice of anybody else around them, is what is influencing the final decisions about the contents of their Advanced Healthcare Directives. And in relation to that, do consider choosing a suitable location to support somebody to fill out their Advanced Healthcare Directives, where it's free from influence or anybody, I suppose, being present that may cause the person not to be able to make free decisions about what they themselves would like. It's important to presume capacity. So, for example, a person with an intellectual disability, with dementia, with an acquired brain injury, and so on, they should all be supported to make an Advanced Healthcare Directive if they wish to do so. A person may require medical advice to understand the consequences of decisions that they may need to make. In other words, in order to make an informed decision, perhaps they need to speak with a GP or with another healthcare consultant to really understand and be able to make that decision with the right information, accurate information. And finally, it's important not to view it as a one-off event. In other words, it's a process, and it should be revisited on a regular basis to check if the person has changed their mind, especially if circumstances have changed for them. I also want to cover the role of an advocate that, potentially can play in an Advance Healthcare Directive. So here's just some of the scenarios where that may be appropriate. So where a person has no natural supports and they require information or specific support to make an Advance Healthcare Directives, where there's an absence of anybody else to do that, they may wish to seek the support of an advocate. Equally, where concerns exist that a designated healthcare representative is not following the person's preferences, or where other issues or concerns exist, the person may require advocacy support to raise a concern with the decision support service. And finally, where duress is being placed upon a person regarding the contents or decisions they have written in an Advance Healthcare Directives, again, it may be appropriate if the person chooses to have an advocate involved. Finally, I just want to mention a couple of things to watch for, be mindful of, that we have encountered in our own work. Firstly, it's important not to make assumptions that the person with a disability would not wish to be treated or resuscitated. It's important that we simply ask somebody and that we never assume just because of a disability or a set of circumstances that we understand what their wishes would be. Secondly, the imposition of unrequested do not attempt resuscitation orders. This just points to really poor practice that we have often come across as advocates. Again, where people make assumptions that perhaps because somebody has an intellectual disability, that somebody else can complete a do not attempt resuscitation order or make decisions on behalf of somebody else. And of course, we know there's no legal basis for doing so. And that's really important as a general good practice, that we don't fall into that trap of making decisions on behalf of other people or making any assumptions. There was a very, I suppose, clear example of that in the UK during the pandemic, where many people with learning disabilities were given do not attempt resuscitation orders without any consultation, any consent, or any ability to inform those decisions in the ways that I've just outlined previously. It's important that we consider and remember flexibility. Preferences for treatment may change over time. We all change our minds on things, sometimes when circumstances change, or we develop a different view on things because of information we've received or experiences we've been through. So again, it's a process, it's not a fixed thing, and we do need to keep a flexible mind if we are supporting somebody who wishes to either withdraw an Advance Healthcare Directive or indeed change the contents of it. Consider if advocacy support is required where any issue exists, as maybe I've previously outlined, or indeed in any other way. Provide somebody with information and contact details for an advocacy service. And finally, ensure that the Advance Healthcare Directive is effectively communicated to the person's key health and social care contacts. So that might include their GP, any other healthcare practitioners they may be involved with, because we know that upon commencement of the Act, there isn't going to be an active register for Advance Healthcare Directives. So it is really important that if somebody has chosen to record their wishes in an Advance Healthcare Directive, that they are supported to communicate that to the key people who need to be aware of it in their lives, so that it can be acted on and referenced if the need arises. So finally, I just want to leave contact details of the advocacy service should you need to contact us yourself or indeed support anybody else to do so. Thank you very much.
Joanne, that was terrific. Thanks a million for that. I really appreciate it. Now, we're going to move to our panelist session where we're going to answer questions that have come in. What we've been trying to do is answer the Q&A as it's popped up, as you can see in the chat box during the meeting. And I'm going to take this opportunity now to ask all our panelists to come on camera, and I'm going to direct some questions that we got in prior prior to this webinar. While I'm waiting for our panelists to come up, I just want to take this additional opportunity to thank my colleagues in the HSE Office of Human Rights and Equality, Caoimhe, Jacqueline, Elaine, Maria and Shauna, and many others who put a huge amount of work into this webinar today and into getting us this far in terms of understanding and implementing the Act, and to assure that we continue to work together to provide knowledge and information for our colleagues. So with that, I'm going to ask some questions now of our panelists. And Sean, I'm going to direct a question to yourself, if that's okay. In the absence of an advanced healthcare directive, but where a patient may verbally state to you that they do not want active resuscitation, where do clinicians stand on that?
Thanks, Siobhan. And that's ordinary care at the moment, isn't it? It's a form of advanced care planning. It doesn't have the kind of legally binding refusal of treatment. But if somebody says, I don't want it, then we document it usually in the form of a do not attempt resuscitation decision in a hospital, for example, and we respect it. It isn't quite the same as an advanced healthcare directive, but it's still an important expression of what the person wants, and we should record it and respect it. And sometimes that's all that happens in a hospital setting, but it might be helpful to put it in a directive form if somebody, say, is moving between settings, and you want to be absolutely clear that their wishes will be respected, irrespective of where they are. Thanks, Siobhan.
That's great, Sean, and thank you. And I think it goes back to our point of documentation, contemporaneous documentation at the time. Absolutely, that's terrific. Mary, I'm going to turn to yourself now. I know you've answered this, but I'm going to go back to it because I know it's a question that's coming up. Is it possible that doctors or indeed other healthcare professionals could be prosecuted for saving the life of a person in an emergency when that person has an advanced healthcare directive, but perhaps the clinician wasn't aware of it?
Absolutely not, Siobhan. That's very clearly stated in the Act that if the clinician is not aware of an advanced healthcare directive, they are not either criminally or civilly liable. So that's that sort of protection from liability is absolutely clearly stated in the Act. Thanks, Sean.
That's great, Mary. Thank you. I'm going to put this question to Sean again, but it is something I'm going to open then to my other colleagues on the panel. So how can we ensure that patients who are approaching end-of-life care have had the opportunity to discuss their plan prior to end of life? Sean, have you any thoughts on that?
Well, I do. It's a professional responsibility. We know people are approaching the end of life. We can see that these decisions are going to come down the line. And I think we've a duty open kind of formal medical about treatment and so on into the broader issues of what's important to you at this time. So I think we take it on as a professional responsibility that we should engage in these discussions. And it doesn't have to be in the format of an advanced healthcare directive. That depends on the person itself. But in terms of the broader one about planning, what's important to you, what do you want to achieve, what are the goals of treatment? So it just goes to the actual core of good medical practice, Siobhan.
That's great, Sean. Thank you for that. And Joanne, do you have anything to add from the service user advocacy perspective on that?
Yeah, thanks, Siobhan. I think it's important to say that starting these conversations can actually be really hard sometimes, but that shouldn't put us off having the conversation. It's really important that we do, step into that difficult territory and raise the topic of future planning, so that people know that they at least have that option to make their wishes known should they choose to do so. And I think often that conversation can best be supported by somebody who knows the person really well, that they're comfortable to have the conversation with. And, it's a good angle to come at, that it can actually possibly offer the person great peace of mind. That's important to bear in mind, that their wishes will be understood and respected. And also, it may offer some further peace of mind to know that family and friends' anxieties may be relieved by knowing clearly what the person's wishes are. Particularly if family and friends hold, quite differing views, perhaps, that the person would be reassured that their wishes will hold strong. Thank you.
No, that's great, Joanne, and thank you. And I think we're all agreed, and having had conversations amongst ourselves as well prior to this webinar, this is all part of a process in the care of the people that we look after. I'm now going to bring in that next question of what do we do in a situation where a person wants one thing and their next of kin or family member may want another. Joanne, I'm going to bring that to yourself first, and then I'm going to widen it out to Brendan next, and then Sean.
Thanks, Siobhan. Again, I suppose this goes back to the heart of what we've been talking about, and giving voice to people's own will and preference. Of course, family is very important, but really the heart of the Assisted Decision Making Act brings to the fore the right of every individual to have their will and preference respected. So first and foremost, that is the key message here, is that the person's own will and preference must take precedent. It can obviously, arise where a person's wishes are not clearly well known, and it certainly would be very appropriate in those circumstances to ask those who know the person best and well if they are aware of the person's will and preference. But that is purely to know whether or not they are aware of what the person themselves would have wanted, not to share their own opinion as to what they feel is right for the person. Thank you.
That's great. That's great, Joanne. Thank you. And if I might use this opportunity to remind people that under our national consent policy, that one person cannot consent for another adult. So it's really important that we note that documentation of consent by one adult for another is not valid. Brendan, can I bring you in on that question of the decision making there?
Yes, I mean, I suppose just to re-emphasize the points already made, that this legislation places the will and preference of the person even more centrally than before. It gives some welcome clarity about the role of other people, which is to help uncover that will and preference. And I think it speaks in terms of Advance Healthcare Directives to the usefulness of appointing the designated healthcare representative to understand the directive, assist with interpretation, and hopefully minimize conflict and minimize difficulty with that aspect of the Act.
That's great, Brendan. Thank you. And Sean, finally, have you any further comment on that issue before I move on?
Yeah, it's the person gets to decide themselves what they want and who they choose as a designated healthcare representative. And we all understand the complexities of families, but this is actually ensuring that the person's voice is heard, rather than, as sometimes can happen, a squabbling bunch of people close to them, however well-intentioned. Thank you.
That's great, Sean. Thank you. Now I'm going to turn to Anya just for some technical questions. Now I know you answered the question about the template, Anya. Can I just ask you, have you any information on what the costs are involved in making an advanced healthcare directive?
None, we hope. I suppose people might choose to get independent legal advice about it, but there should be no costs associated with making an advanced healthcare directive.
Okay, thank you, Anya. And then I'm going to ask you the other question that comes up. Do we have an expected timeline for when we're going to introduce the register?
No, in short. However, we have in recent discussions with the Department of Health noted that there is an intention now to provide those regulations, but I'm afraid no indication of when they'll be in place. We have a register that is capable of accommodating advanced healthcare directives, subject to what the regulations say. But we don't have a definitive timeline yet as to when it will be set up, but probably worth stating, I think everybody has, and I've said it at least twice, that an AHD does not require registration in order to be a valid document.
Okay, that's very helpful, Anya. Thank you. I'm now going to turn to Mary, but again, other members of the panel may wish to come in on this one. Should we ask a person who we can share their advanced healthcare directive with? And what may the implications be there from a data perspective? Mary, have you any thoughts on that?
Thanks very much, Yvonne. That's a really good question. So I suppose one of the things about an advanced healthcare directive is one wants it shared as widely as possible. Now, obviously, as widely as possible among healthcare providers, as opposed to as widely as possible on social media. So we are talking here about within the cohort of people who are going to be working with it. There is no need to seek permission to share, again, within the cohort of healthcare providers. But this is a document which the person making the AHD is going to want and need to have shared, again, within the chosen cohort. Obviously, confidentiality remains an issue with AHDs, just as it does with any other healthcare issue. But sharing among healthcare providers is not a problem. And again, from the perspective of the GDPR, remember this fits a public interest exception, so there's no problem here. But of course, ordinary rules of confidentiality apply once you go outside of the healthcare setting. Thank you.
Okay, that's very helpful, Mary. And Joanne, you might have some thoughts on that as well.
Again, I think just to reiterate what Mary said, the intention of creating an Advance Healthcare Directive is presumably that the person understands when they're making it, that the intention of it is to ensure that their wishes will be known by those who need to. So similar to Mary, it's really just ensuring that it's being shared appropriately as opposed to inappropriately for the purpose of health or treatment. And I suppose the other important consideration is that it's not shared with anybody that doesn't need to see it, particularly before it's enacted if the person loses capacity. Thank you.
Okay, so I think that's very helpful. Folks, I'm conscious that we're coming up to 7 o'clock, so I'm just going to throw open to the panel. Is there any other comment anybody wants to make before we finish up this evening? I think I'd like to take this opportunity to assure everybody that we will be continuing to support you all with the implementation of the Act. I hope everybody found this helpful today. And I'm mindful of the interest that there must be when we still have so many people on at 3 minutes to 7. But on that note, can I thank my panelists and thank my colleagues for all the work they've put into this. And thank you, everybody, for participating and sending in questions. So good evening, everybody, and thank you very much. Bye now.